Affirmative defenses are arguments raised by the defendant in response to a complaint, claiming that even if the plaintiff's allegations are true, there are additional facts or legal reasons that prevent the plaintiff from recovering or winning the case. Affirmative defenses are critical to a defense strategy because they can completely or partially defeat the plaintiff's claims. Common affirmative defenses include statute of limitations, self-defense, assumption of risk, and failure to state a claim. These defenses are typically listed in the answer to the complaint and must be proven by the defendant. Step 1. Purpose of affirmative defenses. Affirmative defenses serve to defeat or reduce liability. They provide legal reasons why the defendant should not be held liable, even if the plaintiff's allegations are accurate. Shift the burden of proof. The defendant must establish the validity of each affirmative defense raised. Clarify legal arguments. Early, affirmative defenses alert the plaintiff and the court to the legal arguments that will be made during the case. By asserting affirmative defenses in the answer, the defendant clarifies their position and provides the court with relevant defenses that could preclude the plaintiff's recovery. Step 2. Common affirmative defenses expanded. List of affirmative defenses. Affirmative defenses are crucial tools for a defendant, providing legal grounds to either reduce or entirely negate liability, even if the plaintiff's allegations are true. Below is an updated and expanded list of common affirmative defenses with descriptions, offering a robust set of defenses that can be used to respond to a wide range of claims. Statute of Limitations. Description. Claims that the lawsuit is barred because it was filed after the legal deadline, or statute of limitations, for bringing such a claim has expired. Example. Plaintiff's claim is barred by the statute of limitations under specific statute, because it was filed after the allowable period. Failure to state a claim description argues that the plaintiff's complaint does not present sufficient facts or legal grounds to support a valid cause of action. Example. The complaint fails to state a claim upon which relief can be granted. Assumption of risk. Description. Asserts that the plaintiff knowingly and voluntarily accepted the risks associated with the activity, thus relieving the defendant of liability. Example. Plaintiff assumed the risks associated with the activity and therefore cannot recover for any resulting injuries. Comparative contributory negligence. Description. Claims that the plaintiff's own negligence or actions contributed to their injuries. In some jurisdictions, this may reduce the amount of damages recoverable. Example. Plaintiff's recovery should be reduced by their own percentage of fault in contributing to the damages. Waiver description. Asserts that the plaintiff voluntarily and knowingly relinquished a legal right or claim, often through written or implied agreement. Example. Plaintiff waived the right to pursue this claim by entering into specific agreement. Estoppel description. Prevents the plaintiff from asserting a claim or defense that contradicts previous actions, statements, or positions that were relied upon by the defendant. Example. Plaintiff is estopped from pursuing this claim based on prior statements and actions. Consent description. Argues that the plaintiff agreed to or consented to the actions now being disputed, thus negating the basis for the claim. Example. Plaintiff consented to the actions in question and therefore cannot claim harm from them. Unclean hands. Description. Primarily used in equitable claims, this defense asserts that the plaintiff acted unethically or in bad faith in relation to the subject of the lawsuit, and thus should not be granted relief. Example. Plaintiff comes to court with unclean hands, having acted in bad faith. Lack of standing. Description. Claims that the plaintiff does not have the legal right to bring the lawsuit because they have not suffered a direct or personal injury. Example. Plaintiff lacks standing to pursue this claim because they have not sustained any injury. Laches. Description: asserts that the plaintiff's unreasonable delay in bringing the lawsuit has unfairly prejudiced the defendant's ability to defend against the claim. Example: plaintiff's delay in bringing this claim has caused substantial prejudice to defendant and should be barred under the doctrine of laches. Self-defense description: used in cases involving physical confrontations, it argues that any actions taken by the defendant were in response to an immediate and reasonable threat posed by the plaintiff. Example: defendant's actions were taken in self-defense in response to plaintiff's threatening behavior. Duress description: claims that any actions or agreements made by the defendant were done under extreme pressure or threats, thus invalidating the plaintiff's claim. Example: defendant's actions were made under duress and are not binding or enforceable. Mistake description: asserts that a mistake of fact or law prevented the defendant from knowingly engaging in the alleged wrongful behavior. Example: defendant's actions were based on a material mistake of fact, and therefore cannot be held liable. Impossibility, impracticability of performance description: claims that unforeseen events made it impossible or impractical for the defendant to fulfill their obligations. Example: defendant could not perform under the agreement due to unforeseen and uncontrollable events. Failure to mitigate damages. Description: asserts that the plaintiff did not take reasonable steps to minimize their damages, which should reduce or negate the defendant's liability. Example: plaintiff failed to mitigate damages and therefore cannot recover for losses that could have been avoided. Release description: claims that the plaintiff signed an agreement releasing the defendant from liability for the conduct at issue. Example: plaintiff released defendant from liability through a signed agreement. Bankruptcy discharge. Description: asserts that any debts or claims against the defendant were discharged in bankruptcy and cannot be pursued. Example: plaintiff's claim is barred by defendant's bankruptcy discharge under federal law. Accord and satisfaction. Description: argues that the plaintiff and defendant reached an agreement, accord, to settle the claim, and that agreement was fulfilled, satisfaction. Example: the dispute was resolved through accord and satisfaction, and plaintiff's claim is now barred. Res judicata. Claim preclusion. Description: asserts that the claim has already been resolved in a previous lawsuit between the same parties, preventing it from being relitigated. Example: plaintiff's claim is barred by res judicata, as it was previously adjudicated. Collateral estoppel. Issue preclusion. Description: prevents the plaintiff from relitigating an issue that was already decided in a prior case between the same parties. Example: the issues raised in plaintiff's complaint have already been resolved in prior litigation and are barred by collateral estoppel, lack of jurisdiction. Description: claims that the court does not have the authority to hear the case or assert jurisdiction over the defendant. Example: this court lacks jurisdiction over defendant due to lack of personal jurisdiction. Failure of consideration. Description: in contract disputes, this defense asserts that the contract lacks adequate consideration, rendering it invalid. Example: the contract lacks valid consideration, and plaintiff's claim is unenforceable. Economic duress. Description: claims that financial pressures exerted by the plaintiff forced the defendant into actions they otherwise would not have taken. Example: plaintiff's actions placed defendant under economic duress, rendering the alleged agreement unenforceable. Lack of capacity. Description: asserts that the defendant lacked the mental or legal capacity to enter into a binding agreement. Example: defendant lacked the capacity to enter into the agreement and cannot be held liable under it. Set off. Description: claims that the defendant has a claim against the plaintiff that should offset or reduce any amount owed. Example: defendant has a valid set-off claim that should reduce any damages plaintiff may recover. Illegal contract description: argues that the contract is unenforceable because it involves illegal conduct or violates public policy. Example: the agreement in question is unenforceable due to its illegal nature. Unconscionability description: asserts that the contract is so one-sided that enforcing it would be unjust. Example: the contract is unconscionable and should not be enforced as it creates an unfair advantage for plaintiff. Asserting affirmative defenses in the answer. After listing your affirmative defenses in the answer, you can conclude with a request for relief, asking the court to dismiss the claims, reduce liability, or provide any other relief that may apply. Sample language for common defenses. First defense: Statute of Limitations. Plaintiff's claims are barred by the Statute of Limitations as defined by applicable statute. Second defense: Comparative negligence. Plaintiff's recovery should be reduced by the percentage of fault attributable to their own actions. Third defense: Assumption of risk. Plaintiff knowingly assumed all risks associated with the circumstances leading to their alleged damages. Affirmative defenses can vary widely in scope and applicability, so consulting with a legal professional can ensure that all relevant defenses are properly raised in your case. This comprehensive list is a starting point for identifying defenses that could significantly impact the outcome of a civil lawsuit. These defenses are asserted in the answer to protect the defendant from liability and to ensure the plaintiff's claims are scrutinized against relevant legal standards. Step 3. Assert affirmative defenses in the answer. When raising affirmative defenses, each defense should be clearly listed in the answer as a separate section, usually following the responses to the allegations in the complaint. Title: each defense. Clearly identify each defense by title, such as Statute of Limitations or Assumption of Risk. Explain each defense briefly. Provide a brief description explaining why each defense applies. This should be concise, as further details and evidence can be presented later in the case. Sample language for affirmative defenses. Below are examples of how to phrase common affirmative defenses in an answer. Statute of Limitations. The plaintiff's claims are barred by the applicable statute of limitations under relevant statute or rule because the plaintiff failed to file the complaint within the required time period. Assumption of risk. The plaintiff voluntarily assumed all risks associated with the activity in question, and therefore, the defendant cannot be held liable for any resulting damages. Failure to state a claim. The complaint fails to state a claim upon which relief can be granted, as it does not meet the legal requirements for a valid cause of action. Self-defense. Any actions taken by the defendant were necessary for self-defense in response to an immediate and reasonable threat posed by the plaintiff. Comparative contributory negligence. The plaintiff's own negligence or actions contributed to their injuries and damages, and therefore any recovery should be reduced or barred. Waiver. The plaintiff waived the right to pursue this claim by previously agreeing to specify agreement or action if applicable. Step 4. Include affirmative defenses in the request for relief. After listing affirmative defenses in the answer, conclude with a request for relief, asking the court to dismiss the case, reduce liability, or grant any other just relief. Example: wherefore, the defendant respectfully requests that this court dismiss the complaint in its entirety, award defendant costs of this action, and grant any further relief the court deems just and proper. Step 5. File and serve the answer with affirmative defenses. Follow the required procedure for filing and serving the answer. File with the clerk of court. Submit the answer, including affirmative defenses, to the court clerk. Serve the plaintiff. Ensure that the plaintiff or their attorney receives a copy of the filed answer.